program. I'm Bob Crimmins, and this is Living in the West. Well, today we're going to be talking about a subject that is extremely important for all of you out there to sit down now in front of your television set and listen to every word my guest has to say, because one day, one way or another, this subject will affect you and your family, and your money that you took all those years to make could be in jeopardy if you don't know where it's going to go after you're gone. So we're going to talk about all that stuff today. So at this time, I'd like to introduce my guest, Amy Halloran.
Hello.
Thank you.
Thank you for having me.
Yes, thank you very much, Amy. Well, I met you through the fact that I needed to have mine updated. I have one, but
Yes.
I needed to get it updated. Which, by the way, that kind of surprised me that I had to do that, or was supposed to after 10 years or things. I don't know. So you can address that issue also.
Sure.
But there's a lot of other things we can start with. Wills and trusts. I would imagine a lot of people think, hey, I got a will, I'm okay. It's all I need, I'm covered.
Right.
Well, I don't know. They don't even know what trusts are, or they've heard of them, or if they have heard of them, they think, no, a trust. No, I'd have to go to an attorney to get a trust and then that would be expensive.
Right.
And so I'm not going to do that. So I can just get this piece of paper I copied off the internet, and it said wills, and I filled it all out and signed it at the bottom, and that's it, I'm covered.
Right.
So maybe we could start with you telling us the difference between a will and a trust.
Sure. Yeah, usually when someone talks about you need an estate plan, that is a comprehensive set of documents that are legally valid, and they're your instructions on how to take care of you upon your incapacity and how to manage your assets upon your death. And so that may include a will, and it may also or may not include a trust. Some like a trust, some don't. A will is what people traditionally think about as the disposition document, then that's all they need. And a will works wonderfully to express your wishes and your intentions upon your death. A will not work for you upon your incapacity. The other thing that people need to realize with a will is that even though it expresses your wishes, the court will need to be involved in a process, it's called probate, and the court oversees the administration of your will to make sure that the assets are distributed according to your instructions. Now, a trust works with
So wait a minute.
Yes.
I have a will, only a will.
Right.
Something happens to me, I die, my family has this now. The court gets involved in it. They
Yes.
probably weren't expecting that to happen, but nevertheless that happens. How
Right.
does the court know, I guess, how that you died, that they're supposed to
Right.
get involved now, or what?
Right.
I mean, what if the family, what if I were to die and the family would get my will and it has all these nice things in it and
Right.
so on and so forth, and then they say, okay, hey, he left us all this good stuff, so they go to proceed to sell the house or proceed to sell the car or some property someplace or something like that. So that's going to
Right.
come to a dead end though, huh?
So from a practical point of view, what a family needs to do when they have the will, if they go and try to do anything with the decedent's assets, that third party, either the bank, the real estate agent, they're going to say, prove you have the authority to administer this will. And so they're going to have to go to court, and
Okay.
your family actually files a petition
So
for
that's how the
probate.
court first gets involved.
Yes.
The
You have to-
family has to go to the court
Yes.
because somebody said, we're not going to give you what you think you're going to get.
Right. They're going to hit those roadblocks that you mentioned because they need court-approved documents
Okay.
in order for the third party to know they're releasing the assets to the correct person.
Okay, so then you were saying the court would decide for you how this is going to get divided up among the four of you that are left, or what?
Well, as long as you have done a very good and comprehensive will, whatever your will states, the court will follow your wishes. If you do not have a will or any estate planning documents, then the California legislature has decided how your assets will be divided, and the court is bound to follow the rules in the probate code. And so if you know that there's...
So politicians will decide for you.
They have already decided. They've already decided.
How your stuff will be divided.
Yes.
Oh, that's a great thought.
Yes. Yeah. So it's very important to at least get your wishes in writing for that reason.
What would you just a rough guess?
Sure.
330 million of us in the United States. How many of us don't have a will or anything?
I've heard.
How many of us are just trekking along, hoping for the best, not thinking about it, not even hoping for the best, not even thinking about it?
Right. Gonna live forever.
Gonna live forever.
Yeah,
And
I've heard numbers as low as 10% have some form of estate planning. So 90% of us are walking around without any
that's
estate
scary.
planning documents in place. The other thing to realize about the court procedure is it's public. And so anytime you file a document with the court, it becomes a public record. So anyone can go to the courthouse and pull the file on your probate action, see how much money you had, who your beneficiaries are, how much they're going to receive. And so
So how does a will, you were talking about a will, help you while you're alive? It can do certain things to help your family members or something, do things for you, or you don't have to have passed on to have a will kick in to force, is that right?
You actually do. Your will does not work for you unless and until you have passed away. The will is only active to take care of you when you're gone. It distributes your assets according to your wishes. Now, if you had a trust, a revocable trust, that is a document that also works to distribute your assets.
So it's the trust that will do
The
this,
trust-
not a will.
Not a will. The trust provides you incapacity planning and post-death planning. So the trust is really a multi-purpose document.
What is that briefly, those two items you mentioned?
So a trust is very similar to a will. It provides instruction on how your assets should be managed upon your incapacity for your benefit, and how should it be distributed upon your death.
Right, but how does it help you while you're still alive? How can it help you?
So if you while you're living and you're competent to make your own decisions, your trust just kind of sits there and you don't really think much about it. If you become incapacitated and are unable to make your own financial decisions, you have named a successor trustee. The trustee is the manager of your trust. You've named someone to step in to become the manager of your assets upon your incapacity. And that person may step in without the need for court approval. And that's a big distinction between a will and a trust as well. You don't need the court in order to have your named successors use their authority in the document.
So if you have a will, you may go to the bank and come to a brick wall trying to collect your parents' money or whatever. But if you have a trust, then you can go to the bank and then that brick wall's not there.
Right.
And you don't need the court to give the bank permission to give this to you.
Exactly. Now the court is available if your successor trustee happens to not be doing their job correctly. Then the court is available to order the trustee to do the job right or to put a new trustee in place, but you're not required to be in the court to get the balls rolling.
Okay. So let's say I make this thing out, and now a few years down the road, oh no, I want to change that. I want to change something.
Yeah.
So let's say I don't know if there's a difference between a trust and a will as to how you would change something in it, or would you do it the same way for both of them, or how does that work? How would you change something?
Right. Because both a trust and a will are legal documents, you do need legal assistance to amend either of those documents.
So I can't take my will and erase this line here and then write in a new line and then put my initials next to it, and then it's locked in.
You cannot. Those
can't do that.
interlineations would not be considered legally valid. So you want some legal consultation to make sure your amendments are also legally valid.
So I got mad at my uncle and I didn't want him in anymore. I
Right.
can't rub him out and
Right.
write in somebody else.
You
do
can't,
that.
no.
Got to go to the attorney's office.
Exactly.
Okay.
Yeah. And it's tempting. I know it's tempting to feel like it's easy to do this on your own and pull something off the internet and
Right.
fill it out and sign it.
Right.
if you do that, I still recommend having an attorney just look it over, make sure it does exactly what you want it to and what you think it should do.
Because if it doesn't, it would be too late.
Right.
Because you would be gone, and then you're going to be laying misery perhaps onto your family.
You could be making things very difficult and causing confusion and not knowing how to distribute assets.
You know, that's another thing. The way people need to look at wills and trusts are, this is not something for you.
No.
This is something for your family, that you're trying to protect your family
It is
against
a gift.
some real grief. And there's a couple of questions I want to ask you about that will show people how this can turn into bad things in a family.
Right.
If it's not spelled out and laid out there for them so that they understand what you would want to have happen and so forth. Not, no, Dad want, no, yes, no, he didn't. And, well, no, it's right here. Says in black and white, this is what Dad wanted to happen.
Yes. Yes.
So people have to think, to not be selfish and take the time that it takes to get one of these things and get it filled out properly with the guidance of an attorney or something to make sure that it's done right. Because it's not for them, it's for their families, and everybody wants to do nice things for their family. We don't know.
Right. Nobody wants to sit down and spend money and talk about their death, but I truly believe it's a gift you give your family because you're giving them the roadmap. Here's what you want them to do when you're not here to explain yourself.
You know, it's like, okay, marriages. One family, two families, different families come together.
Yes.
Get married. He has 2 kids, she has 3. Here they are. They don't have any wills or trusts.
Right.
But they have a lot of money. They have a nice house paid for. They got some nice cars. They have money in the bank. They have stuff. But they're both killed in a car accident sometime.
Right.
Okay. Wow. Yeah, it's a situation. Kids from this side, kids from that side, and then the adults of the kids on that side and the adults of the kids on the other side coming together to try to figure out stuff and who gets what, and wow.
Right. Well, remember, if they have nothing in place, then the California legislatures will have their priority list and will say who gets what. That may not be how the married couple intended it to be. I think it's very important to realize that the statutory scheme, it's general. It's very general, and it's not going to consider individual circumstances in your family. Perhaps some of those kids have grown up and are on their own, but some of them are minors and still need taking care of. And so the benefit of sitting down and doing it yourself is being able to tailor your distribution provisions to the exact circumstances of your family.
Right. Same way as if someone was married, some guy was married 3 times. He's got 3 ex-wives out there. And he dies and never had a thing to protect anybody. And here the 3 of them come.
Well,
does the court get in that too?
Well, the family court helps us out a little bit.
And if the family court gets in that, how do they make that decision? Well, which wife? What's the pecking order of 3 ex-wives? Or
yeah, legally you can only have 1 wife. So if you're married to one of them at the time, she has the priority. Once a marriage is severed, that legal relationship between the spouses is severed.
Does she have the priority totally?
Yes.
Over the other 2?
Yes. And of course you have to look to see whatever any marriage settlement agreements might say. Those have to be considered as well. A marital settlement agreement may give some sort of right to an estate down the line. It's unusual, but that could happen.
So like in a divorce degree or something.
Right.
Okay, when I pass on, yes, okay, I'm not married to you anymore, but yes, you can have the cabin up there at Lake Tahoe, you know, and stuff like that, you know.
Right. Again,
but if that's not in writing, in a will or in a trust, bad problems.
Yeah, you're in court. You're in court trying to settle it out, trying to work it out, and probably there are some kids from those marriages who also have an interest in that.
See how sticky this stuff can get?
It gets very sticky and very ugly, and I will tell you a lot of times disputes among families are rarely about what's in the will or the trust. Kind of old resentments start showing themselves, and
Right.
people start battling over the principle of the thing rather than what makes sense. So emotions run high.
Right. Same within, I guess, people that are in business. They got a partner.
Mm-hmm.
I guess there's business wills or trusts or something like that, right?
Sure. Buy-sell agreements. A lot of times you'll see key man life insurance policies
But do they always have those business people? I don't think so. They're just regular folks, and they went into business, and they got a partner now, and they're going along there, and one of the partners dies, and there's a lot of stuff there that the other partner thinks they should get.
Right.
And the kids are saying, no, wait a minute, we're getting it, we're the family, and you're out, and then you got another explosion.
Right. And a good estate planning lawyer, if you came in to do your own estate planning, a good estate planning lawyer should follow that trail and get to the fact that you have a business partner, and that should be incorporated into your estate plan to avoid disrupting the business or having a child, an adult child who has no idea how to run the business, sort of suddenly inheriting part of the business and putting their 2 cents in.
Right.
So another reason to have some legal consultation so that all of your assets are incorporated consistently and your family's protected financially, but then your business partner also can continue with the business without disruption.
Right. And it's interesting, isn't it, to think of all the things that can happen that are really not nice.
Right.
And people aren't putting much effort at all into getting around to getting one of these wills or trusts or something.
Yeah, and it's challenging too, I think, for, there's a lot of...
And a big old list. It's like the second one from the bottom.
Oh, it's on everybody. I mean, it's always on the list, and it never comes off the list. It never comes off the list.
Right.
It's hard. People with minor children really need to think about naming guardians in a will or a trust.
Oh, yeah. See, now, I never thought of that. That's part of it, too, huh?
That does require court intervention. And without the court will always follow the parents' guidelines of who they've said should be the guardians. But if you haven't put that in writing, the court just has to pick from whoever walks into the court saying, oh, no, I know they would have wanted me to raise their child.
Oh.
And so that's a very important piece of estate planning for those with minor children. The other thing is, a lot of people with minor children are worth more dead than they are alive, because the life insurance will pay, the house will sell, and the equity gets pulled out of the house, and suddenly you've got maybe a 14 and 15-year-old child who's going to inherit all that money, and you want to put your parameters on that money. How old is the child when they get to inherit that money? Do they have to finish college?
That is another point. Let's talk about this for a second. Okay, so the parents die, and they've got some kids, and they're 14, and they're 12 and 14 and 18. And there's no will or anything. So, the court gets involved, and the court says, yeah, okay, it's the 3 kids, and they're going to get it. Okay, so fine, the kids get it.
Right.
But what's a 14-year-old going to do with $100,000 or something?
So here's what happens. So the 3 kids would split it equally. The 18-year-old is a legal adult and gets their share outright and gets to decide how to spend it, how to invest it, what they're going to do with it.
Right.
Most people don't feel 18-year-olds have sufficient maturity to make those kind of decisions. For the 12-year-old and the 14-year-old, the court will appoint a guardian to manage that money. A court guardian? It may be a family member or someone that the child knows, but the court will be involved to oversee that money, the investment and spending decisions, again, until that child reaches 18. So a lot of parents put into their trusts.
So they might appoint an uncle who has a gambling problem to watch over that 14-year-old's $100,000, right?
If that uncle's able to keep that gambling problem from the court, absolutely. It may not even be that extreme. It could just be your sister who loves your kids dearly but doesn't really balance her own checkbook.
Right.
Let alone being able to invest and make spending decisions for a large sum of money.
And by the time the child hits 18, it's not 100,000 anymore. It's 28,000 left.
Right, right, right. Which is even a lot in an 18-year-old's pocket.
Yeah, right.
But yeah, you know, most parents have intended what they've built in their life insurance policy to, you know, finish a child's education, get them a start in life, maybe help with a down payment for their own home. And so a lot of parents will put terms into their will or trust that say, you know, hold this money until my child turns 25 or 30. And, you know, then the person that you've chosen, who is financially responsible and will make some good decisions, can make those investment and spending decisions on behalf of the child. And so that hopefully you don't get to the distribution age and it's gone because it's been frittered away or invested poorly, but maybe it's actually been spent on a good education and a travel abroad program or other things that are important to the parents and the children.
And you know, people don't want to admit it, but you get a lot of money involved. Mm-hmm. And they're not who they were.
Yeah.
At all.
Yeah. No, it's true. And there are a lot of ways to define fair. You know, you can put 3 kids at the same table
right.
and they'll all have a different decision of how to fairly divide the assets.
Yes, absolutely. So I would think with just some of this stuff that we've talked about, hopefully we've scared people enough to where they're going to make that decision to change this now. And it's not like I'll get around to it because who's got the lock on when they're going to be called off the planet Earth? You know, we don't.
If we could